So good morning, everyone. Welcome back to our weekly webinar series. Today, we are taking up recent case laws, judgments uh, on PUFE transactions. So over to Anil, sir.
Thank you, Ankit. Namaste to all my participants. This is our 37th weekly episode. Although there are many other episodes much before this weekly series. So we have been now doing for the last 37 weeks without any break every week. Earlier it was Sunday. First it was 1 p.m. Then on the demand it was shifted to 4 p.m. And then again, everyone, we got the feedback that the Saturday would be a better time and let the Sunday be available for the family or entertainment time. So therefore, we hope that we will continue this and the subjects that we have chosen for all these weekly episodes is one, the Insolvency and Bankruptcy Code, SURFACE, latest judgments on all these issues, specific issues. And we are also likely to add now the mergers and acquisition sections of Companies Act with practical experiences and with the judicial pronouncements on that. Also, we are likely to add into our series the recovery of debt, may it be by MSME or may it be by any other business entity. So our focus as AAA organization, one that we have a chartered accountancy firm, we have a SURFACE firm where we outsource the SURFACE actions by banks and ARCs and NBFCs. And AAA is the largest service provider in that space. So far, the banks have given us more than 32,000 cases in that company called AAA Capital Services. Then we started with insolvency professional entity, and we became the largest insolvency professional entity with the 75 partners and more than 280 assignments of CIRP and liquidation. Then we started with the valuation, and where the Ankit is the CEO of the valuation, chartered accountancy is also being handled by Ankit. And then is the law firm, the AAA Legal Professionals LLP, where we are focusing on IBC, SURFACE, and all matters of DRT, debt recovery tribunals, and the mergers and acquisitions under the Companies Act, and also all possible efforts that can be made for recovery of debt. And that includes IBC, recovery through IBC, recovery through commercial courts, recovery through negotiable instrument, and also a recovery through the MSME framework, where the councils have been made and the government is very serious about it. In fact, today, till now, 137 councils have been made for the handling the dues of MSME sector in India. Also, what kind of criminal actions can be taken against those people who are not paying their dues. However, today's episode is focused on the avoidance transactions under the Insolvency and Bankruptcy Code, where we will cover the transactions covered in Section 43, means the preferential transactions. Section 45 means the undervalued transactions. Section 49, which are again the undervalued transactions with fraudulent intent. Section 50, which are the extortionate credit transactions, and Section 66, which is the fraudulent transactions and fraudulent trading. This is the focus today. So we would, so Ankit, we have never given any kind of brief about our intent, and today it is the first time that we have given some detail about a AAA group. So would you like to add anything? Because I think I didn't say anything about this AAA valuation entity, and you can add, and also the chartered accountancy firm, we are doing the forensic audit and also the ASM. So you can add a couple of things. In the meantime, I can share my screen.
So the idea is, of course, that in AAA valuation, the idea is to have a geographical spread across India. And then we did recently get an award from IOV RVF for the maximum valuations done by an entity, registered valued entity. So that way we are trying to build more capacity, take up more valuation work. So that's the objective there. And yes, within the CA firm, we are supporting a lot of insolvency professionals already with respect to the requirements of forensic audit or transaction audit, or rather there are other requirements that an insolvency professional has, which can be met by a CA firm. So I think let's start and talk about the topics that we have at hand. I think some interesting judgments of PUFE, which will allow us to take care of this very important part of insolvency, because I think this is the first a question that many people ask, that how are you preserving the assets that are lost before CIRP? So let's understand what recent judgments talk about.
So, Ankit, we are today discussing 7 judgments of NCLAT, and there are 5 judgments of adjudicating authority, NCLT, and of course 2 judgments which are much older and known. That is, one is the Anuj Jain IRP for JP Infrastructure Limited versus Axis Bank, and then the second is from Delhi High Court, Venus Recruiters Private Limited. So these are the judgments that we will deliberate today, and with the names of the judgments we will take when the judgment will be discussed. However, the issues, so these are the issues which are deliberated in these judgments, and we'll just see what are the issues that we will discuss today. So one, whether proceedings on fraudulent transactions under Section 60 of IBC can be initiated in the absence of any transaction audit. Second, whether Section 66 of the code includes a look-back period for fraudulent transactions. Next, whether there is any scope for resolution professional to take any action for fraudulent transactions covered under Section 43, 45, 50, 66. It should not be fraudulent, it should be avoidance transaction. Beyond the timeline stipulated under CIRP regulations 35A, whether the RP can file an application under Section 66 of the IBC after a resolution plan has been approved and the office of the RP has become functus officio, whether the NCLT is competent to pass an order under Section 66 of the IBC during the moratorium under Section 14 of the IBC, whether the restrictive order passed by the adjudicating authority imposing restrictions on the ex-directors from leaving the country are in violation of Article 21, whether the stipulation of future recoveries from Section 66 of avoidance application being retained by the successful resolution applicant amounts to illegality, or whether the same is within the commercial domain of the COC, whether the liquidator or resolution professional is allowed to investigate the transactions executed by the corporate debtor beyond 2 years from the insolvency commencement date. These are the judgments from the NCLT. So far that I was reading was the judgments from NCLAT, Appellate Authority. Now we will read some of the judgments, the issues that we will handle. Whether a dissenting financial creditor can file an application under Section 66 of IBC, whether the audit of 6 years is beyond the purview of IBC as per Section 43 and Section 50, dealing with preferential and extortionate transactions, respectively, which provides for look-back period of 2 years preceding insolvency commencement date, whether the provisions of the Companies Act can be invoked for matters of execution of an order passed under the Insolvency and Bankruptcy Code, whether the respondent, who was neither the promoter or suspended director nor part of the management of the CD, can be held liable under Section 66 of the Code, whether bad commercial decisions can be considered as fraudulent transactions under the provisions of Section 66. Now, these are the judgments that we will take one by one. This Nitin Bansal, the ex-director promoter of Stock Flow Express Private Limited, and the liquidator in this case was Sanjay Gupta, and this is an NCLAT case of 2022 and May 22 rather. Whether the proceedings on the fraudulent transactions under Section 66 of the IBC can be initiated in the absence of transaction audit or forensic audit, whatever you call it. Before I go ahead and read about the facts of the case, I may even say that there is no provision in the IBC or in the regulations which provides for the appointment of a forensic auditor or a transactional auditor. It is by tradition, and it is by the way the law has been structured, since the insolvency professional cannot be considered to be an expert in unearthing the transactions under Section 43, 45, 49, 50, and 66. Therefore, by tradition, it has been continuing for now 6 years since inception, that a forensic auditor or a transactional auditor would be appointed, and the fee would by the RP, and the fee would be approved by the committee of creditors. So there is no requirement as per code or as per the regulations. So in this case, there was non-cooperation from the management of the company, and the RP analyzed some documents available and framed an opinion that there are transactions, and made a determination that some transactions have taken place which are covered under these avoidance transactions sections. So filed an application before adjudicating authority, and also submitted before the adjudicating authority that the management failed to cooperate in providing information, important documents and information that the transaction auditors were not, the transaction auditor was not able to submit his report. The adjudicating authority allowed this application, and the suspended director, in fact, went for an appeal simply against that order where the application was allowed. So now in this case, the basically appeal was filed against an interim order, and in the interim order, nothing was mentioned. The only issue it was mentioned was that there is no audit. So the appellate authority first heard the appellant, and the appellant said that the adjudicating authority has granted or has admitted the application in the absence of transaction audit report, as no audit was ever concluded on any of the allegations made in the alleged transactions. The appellants were held liable under Section 66 of the Code solely on the basis of the IRP's own analysis. Further, the argument was made by the appellant that the IRP has failed to establish that the sale of the shareholding by the appellant was done with the intent of the fraud. This is regarding the transaction. So there is a transaction regarding shareholding, sale of shareholding. Now the respondent, means the RP, says that since there was no cooperation on the part of the appellant in providing any kind of information, that's the reason that the transaction auditor could not submit the report. And also on account of the complete non-cooperation from the appellant, conscious efforts were made by the RP, and some transactions were ascertained, opinion was formed, and determination was made, and an application was filed as per Regulation 34. So that's what the argument from the RP was, and it was held by NCLAT that the application was admitted rightly, and it was observed that the transaction audit could not be conducted due to the failure on the part of the appellant to cooperate the IRP, and also based on the document placed before the RP, the transaction conducted while the corporate debtor was in control fell under the category of fraudulent transactions. So any comment on this, Ankit, by you? Ankit, even also in your name, my photo is being used today. Okay, so I think I will move to the other judgment, which is Thomas George versus K. Iswarapalli, the resolution professional in the case of Maths Raman in Manufacturers and Traders Private Limited. So this is again NCLAT judgment in December 22. It's a very, very recent judgment. In fact, this Iswarapalli, the resolution professional, is partner of AAA Insolvency based out of Kochi, Kerala. So in this judgment, it was the basic issue was that whether Section 66 of the code includes a look-back period for fraudulent transactions. Because see, in this case, when this application was filed, even the suspended director of the CD approached the NCLAT under Section 61, where the question that arose was whether Section 66 of the code includes a look-back period for fraudulent transactions. So the appellant said that look-back period for Section 66 to be construed 3 years. This was the argument of the suspended director. Then 3 years, because of the law of limitation under the code, is 3 years from the date of default. And also, Section 66 of the code is also governed by the Provisions of Limitation Act, which limits the time of look-back period to 3 years since the statute of the limitations for the proceeding. And in this case, the NCLAT held that unlike other transactions provided under the code, Section 66 of the code does not include a look-back period for fraudulent transactions. Section 66 of the code envisages that the losses caused to the creditors are recovered in the event of the liquidation, and that the directors who causes such losses are to be made liable to make good such losses. Therefore, the RP is free to investigate and address any wrongdoing at any pertinent time without time restriction and dismiss the appeal. In fact, in some of the other orders, the look-back period of 6 years and even beyond that was also considered as within the powers of the RP and the COC. Ankit, so far we have discussed one issue, that without a report of an auditor, whether the application can be filed and whether an order can be passed by the adjudicating authority. And second that we are discussing is the whether there is any look-back period or in
Section 66. Yeah.
So these are the two. I think these are the clarities that we are now getting from the NCLAT.
I think this is confirming the stand that we have been taking, that yes, one, there is no requirement for a transaction auditor. The transaction auditor's report might be able to substantiate or better substantiate the transactions, or maybe discover more transactions than maybe an IP can do himself. But then, yes, the second case also, the look-back period is something that I think the same understanding has existed amongst us.
So the third judgment is Prashant Chandra Rath, a suspended director of the corporate debtor versus Surya Kant Satapathy is the RP. NCLAT judgment, New Delhi, September 22, and where this issue was whether there is any scope for RP to take any action for fraudulent transactions covered under. In fact, fraudulent transaction means avoidance transaction. It should have been avoidance transactions covered under Section 43, 45, 50, 66 of the IBC beyond the timeline stipulated under the CIRP regulation 35A. Now, 35A regulation talks about the timeline for RP for the purpose of forming an opinion, for the purpose of determination of the avoidance transactions, and then for filing an application before the adjudicating authority. So these are the three things where the timeline is provided in Section 35 capital A in the regulations, EIRP regulations. And in these cases, all these were delayed, or we
I
were.
remember that we have discussed this judgment in an earlier webinar, and this one was where I remember talking about
Yeah,
this judgment. So I believe here the suspended director had made an argument that the fraudulent application should not be pursued because the application was beyond the timeline of 135 days. So that was rubbish by NCLAT, saying that this is all discretionary and not mandatory, these timelines. So that was the, I think, the
yeah,
decision given by them.
absolutely, absolutely. I think you can also see what kind of submissions were made by the appellant, which is there on the screen.
Yeah, so this is timelines prescribed are of special significance in the present matter since the promoter are eligible to act as resolution applicant. So this is the argument that they made, that beyond the timeline it should not have been pursued. So OTC, so the respondent had said that the OTS proposal was only for stalling the COC proceedings and there was non-cooperation on submission of accounts, etc.
Yeah. No, I
So
think it was very clearly held.
yeah,
Already said that it very clearly it was held. And it was also based on a judgment from Madras High Court, and that was Shaji Purushottam versus Union of India. So that was also a judgment which was relied upon. Next coming is Rigan Power Tech Private Limited, represented by RP Ebenezer in Baraz versus Viral Control Private Limited. Again, NCLAT judgment from Chennai. NCLAT Chennai judgment, it was in 2022. And the issue involved was whether the RP can file an application under Section 66 of the IBC after the resolution plan has been approved and the office of the RP has become functus officio. So in this case, RP filed an application under Section 66, and NCLT dismissed the said application and observed that the CIRP had attained finality and that RP cannot become functus officio and cannot file or pursue any application on behalf of the CD. Being dissatisfied with the impugned order, the passed by the adjudicating authority, and appeal was preferred by the RP before the NCLAT. Now, appellant says that the adjudicating authority made an error considering the relevant clauses of the resolution plan, which while uploading the third party's untenable objections, defrauding the vendor. The resolution plan mentioned a clause that allowed the RP to maintain Section 66 applications filed during CIRP even after the plan was approved. Even after the plan was approved, there was a condition in the resolution plan, and the resolution plan, in fact, provided these clauses. So this is what was submitted by the appellant. However, it was held that NCLAT, the Honorable NCLT, that we cannot proceed any further to file prefer application under Section 6 after the resolution plan is approved by the adjudicating authority. As per the resolution plan, the COC is required to take the application. COC is required to take the application to its logical end, and CIRP had attained finality and that the RP became functus officio, and he therefore cannot file or pursue any applications on behalf of CD. Section 23 of the code clarifies that the role of the RP is in managing the affairs of the CD during the resolution process and not later. So I still feel that this judgment, where we are seeing that the basic issue is whether the RP can file an application. This actually has the background of wearing the former hat, that is from a Venus Grouter judgment from Delhi High Court. That probably is playing while this judgment was being made. Now we move on to Rakesh Kumar Jain versus Jagdish Singh Nain and others, and that is April 22. This is regarding whether the NCLT is competent to pass an order under Section 66 of the IBC during moratorium. Now, what exactly they are saying that you see, in fact, promoters or the suspended directors, they try their best to avoid these transactions application. So some of the advocates must have somehow influenced the promoters that Section 14 is there, so nobody can move against it. So Ankit, you can just read and then add your own understanding into this.
So this is HPN Foods. They're the RP had filed the 66 application under Section 66 of the code. The proceedings was initiated under Section 66 of IBC and was allowed by NCLT. Agreed by this order of the NCLT, the RP of the corporate debtor filed an appeal before the Honorable NCLAT on the ground that an order under Section 66 of the IBC inter alia concerning defrauding of creditors of the corporate debtor could not be passed by NCLT during the pendency of moratorium under Section 14 of the IBC.
So basically, like it's not really correct. Somebody must have wanted to take some time, because the moratorium is proceeding against the company. But this is not proceeding against the company. This is proceeding against
this is proceeding for the company rather.
Yeah,
because you're talking about diverging of assets or some harm caused to the CD itself. So it can't say that.
Yeah.
Let's see the next page. This is all okay. The appellant submission was not very substantial. So basically it talks about Section 65 was the argument that Section 65 provides for adjudication of issues pertaining to corporate debtor during the course of CRP or liquidation process. So that is the argument that the respondent took. So that's a valid argument that we are working for the company. So held that harmonious reading of 14 and 66 along with Section 65A of the IBC, it was held that by the NCLAT that the impugned order passed by the NCLT under Section 66 of IBC was in accordance with law and did not attract any bar. So it was further observed that 14 only prohibits institution and prosecution of the proceedings against a corporate debtor, but does not prohibit passing of orders by NCLT in pending insolvency or liquidation cases. So I think it's in line with what we think, that the company can file suits or take action against other entities during the moratorium period. It is only that the action against the company needs to be paused so that the company's survival chances increase. Also, of course, avoidance transactions, they have held that this is all valid.
So moratorium cannot stop the...
Yeah, and also, if you say that Section 66 application cannot be applied, then Section 66 will become infructuous, because you can't file an application anytime then. So anyways, yeah, I think it was only a time buying criteria adopted by somebody.
Challenge with the NCLT is that they actually have to see any application, and so in very rare cases the applications are disposed of on admittance day, and that also the reason would be
this is our frivolous litigation.
14 for this is just a wastage of time.
Yeah, frivolous litigation like this needs to be kind of discouraged. I don't know what would be the way, maybe putting on costs or something else. I don't know. Let's see. So Amandeep Singh Bhatia versus Vittal SA, and this was an NCLAT judgment, August 2018 judgment. The question was whether the restrictive orders passed by the AA imposing restrictions on the ex-director from leaving the country are in violation of Article 21.
Very important issue, because I would rather say to all my listeners that wherever you feel that the fraudulent transactions have taken place and the promoters, they should be restrained from going abroad. That would be really good in case we want somebody who actually can provide some information by just this thread. Yes, Ankit.
So the appellants are ex-directors and as well as personal guarantors. And during the liquidation proceedings, one of the operational creditors had filed an application before NCLT seeking directions against ex-directors to submit their passport before the registry. So, in view of the said application, by the order, Honorable NCLT imposed restrictions on the ex-director. So the appellant, dissatisfied by the order, went to NCLAT. So let's see what the NCLAT do. The Honorable Supreme Court has jurisdiction under Section 142 of the Constitution to direct the Director Officer of the CD not to leave the country without the prior permission of the Honorable Supreme Court. That the IAAA does not have powers under the code to pass such orders, so that the impact order is also against Article 21 of the Constitution. These are the arguments made by the appellant. Let's see the respondents. It was held that that as per NCLAT, that after investigation, if any report is filed against the ex-director, it will always be open to the AA to the adjudicating authority to pass appropriate order under Section 66. However, it cannot be stated that the adjudicating authority cannot direct the ex-directors not to leave the country without prior permission of the adjudicating authority. And if any order is passed under the law, it can't be held to be violative of Article 21. So the adjudicating authority has not stayed the moment of the appellants, but only observed that if they intend to leave the country, they should take permission of the AA. So they kind of distinguished it. They said that we are not saying that, okay, you don't go abroad, but they say that if you want to go abroad, you take permission and then go. So I think that's a narrow line, or it's a
I
very
think this is what it always happens in even other cases also.
Yeah, even I think that's the order. I have seen some orders like these passed in other matters, criminal matters also. There again, I think the court doesn't say that, okay, you're not allowed to travel. They will always say that, okay, you don't travel, and if you want to travel, then you take our permission.
Give us the reason and then we will allow you. That's what it is there.
Yeah. So 63 Moon Technologies Limited versus the administrator of DHFL, DHFL, yes. So this is January 2022, NCLAT judgment. So whether the question issue at hand, whether the stipulation of future recoveries from Section 66 avoidance transactions being retained by the successful resolution applicant amounts to illegality, or whether the same is within the commercial domain of the COC. So that's a issue which is practical issue when you're preparing the resolution plan. Several times this question has come up that, oh, if application is filed, then who should get the proceeds? So there are
in
different
this particular case, even the resolution plan said that all the proceeds from avoidance transactions will go to SRA. So this is where the challenge was, that the commercial wisdom of the COC can be challenged at some point of time where it is not really appropriate. All this fraud, all kind of transactions, the money lost by the creditors cannot go to the successful resolution applicant without even he factoring in, without even the resolution applicant factoring in the value of these avoidance transactions. So this is where the question was on the commercial wisdom of the COC, whether this includes in that or not.
Well, practically speaking, the case is very different. Practically speaking, once the resolution plan goes ahead, then there is almost nobody who follows up on the avoidance transactions unless and until the creditors keep a focus on it. And therefore, the idea that if the avoidance transaction proceeds are falling into the pocket of the successful resolution applicant, then maybe he will be able to chase and get that money from the people who have taken those assets away from the company. So the idea is that whether COC gets enough value for these avoidance transactions from the successful resolution applicant or not. I think that's also important. That's again
when we actually see section 43, 45 and section 66, what it says that by all these transactions, if an order is passed, according to law, the proceeds will go to the corporate debtor.
Yeah.
In all the three sections, it is very clear that the proceeds will go to corporate debtor, because in case you see the orders which can be passed by the adjudicating authority, and if there is any property which has to vest back to the corporate debtor, if that also means the corporate debtor, not the resolution applicant. So in this case, the COC decides, since the resolution applicant could not kind of factor in the value of these recoveries from avoidance transactions. Therefore, the COC in most of the time says that these are the excluded assets from the resolution plan, and the RP or whatever provisions are made in the resolution plan, based on those provisions, the application will be seen finality, and after that, whatever the recovery would be, that would be distributed to the creditors. So this was also the opinion given in Venus Recruiters of Delhi High
So
Court.
there's an associated question to this, which is on the question box, which says that as a COC member, is there an entitlement to the copy of the PUF transaction filed with the AA? Because see, a COC member will also include the promoter, let's assume. So if the application comes to the promoter, I don't think there is a conflict if it goes to the creditors, but if it comes to the promoter, then there can be a conflict where the promoter can actually view the application itself. So what do you think about that?
Even if the application is filed before the adjudicating authority without even informing the promoter directors, but a notice has to be given, and these are the cases where the without notice to the other parties cannot be simply dismissed, or cannot be simply order cannot be passed.
The copy of the application perhaps is already with the respondent. That is a requirement. But then copy of application with some other COC member, that's the question at hand.
Not a question of copy of application, because the filing an application before the court, that will any case will be officially served to all the respondents. So what exactly the question can be, whether this transaction audit report and whether
I think the question is very simple, that can a PUF application filed with the AA, a copy of it is required to be produced before the COC, or it is not required?
The copy of the application is not required to be produced. Rather, the transactions on which the applications are being made, the forming an opinion and the determination of the RP, if these are discussed in the meeting and also minutized, I think that is what is the minimum requirement. Even otherwise, it is the COC is not really bothered. The only thing is that the COC can provide some additional information in case these are discussed. The COC can never say that the RP filed the application without our approval. This is not required. RP doesn't need COC's approval for filing the application. RP also does not need even to discuss this forensic audit report with the COC. But in case we really see the intent is that the COC also would support the RP in finding the illegal transactions or avoidance transactions. Therefore, whatever application is being filed, or whatever transactions, wherever transactions are being determined, that information should go to the COC, so that if there is any factual error, that can be corrected in the COC based on the information that they have. Beyond this, there is no role to COC.
The transaction audit report should be shared with the COC members, right? Or the CC members. That's your recommendation.
Report or the transactions on which the RP has formed an opinion and have determined. Those things only has to go to the in case COC wants to discuss the report, that's okay, but RP should present a case where the transactions which are determined should be reported to COC. Okay. Because they can add value, but they would not be able. But then, because it sometimes the RP also can include the secured financial creditors, banks, etc., into the respondent list. But that's what actually will disturb them, and therefore somebody might have asked that we need the copy of the application which are being filed.
Yeah. Another quick question, that in case there is an avoidance transaction and the avoidance transaction is basically reversed by the person who has taken the money away or sold the asset in an undervalued transaction, etc., etc. In that case, there is no need to file an application NCLT, right?
No,
If the
then
money is
there is
already
no need.
recovered.
Then
Yeah.
there is no
So I
need.
just wanted to confirm that.
Then there is no need.
Yes. So let's go forward then and think
Yes.
we. So this is Amardeep Singh Bhatia versus Abhishek Nagori for Asian Natural Resources India Limited. This is in November 22 judgment, very recent judgment.
Whether
So
the liquidator or RP is allowed to investigate the transactions executed by the corporate debtor beyond 2 years from the insolvency commencement date. So I think it was very clear in this case. Right? See, like when we talk about the applicant is an RP. Now, in this case, the applicant was some of the shareholders or promoters of the company.
okay.
Now, the RP or the liquidator is asking information, and that information is beyond 2 years. Now, since a lot of lawyers, they are trying to find ways to get an exit route from these transactions, so they somehow thought that this might even work, and they said that the beyond 2 years he cannot even investigate it. Now, the court was very clear in this that although the look back period for section 43 and 45 and section 50 is extortion or is 2 years, and in 1 year subject to related party and non-related party. However, the period for fraudulent transaction, there is no look back period. So therefore, the RP can, in fact, the RP or the liquidator can investigate the transactions beyond 2 years. And the court have said that he would not know whether these transactions would fall under what section, since there are different timelines in section 43, 45, 50, and then there is no timeline in section 66, and the section 66 timeline says that it can, as suggested by the circumstances. So therefore, the promoters are supposed to provide the material documents. The promoters are supposed to cooperate for the investigation for a longer period. The promoters cannot say that you restrict your investigation only for 2 years. And it was very clearly held by appellate authority NCLAT that unless the liquidator is in possession of all the documents, he cannot determine whether there are any transactions or not during the relevant period of time. And therefore, the corporate debtor cannot deny these documents at the threshold itself. Then there is no look back period specified under section 66, which refers to fraudulent transactions. If the liquidator finds that there is a fraud committed by the corporate debtor at any time, he can approach the adjudicating authority. Appellate authority the appellate cannot deny handing over the documents on the ground that the look back period is only 2 years. Now, Ankit, there are some judgments from adjudicating authority, NCLT, and we can take up one by one. Like, so you can take up this judgment of Ambit Finvest Private Limited versus Rakesh Niranjan Ranjan and Mumbai Bench NCLT judgment dated 17th of June 22.
So the question here is that whether a dissenting financial creditor can file an application under section 66 of IBC. So let's see what it says. So the fact is that the application was filed by the dissenting financial creditor applicant under 66 of the code, and further by the same, the applicant also prayed for dismissal of the resolution plan. The respondents were disqualified under section 29A, that was the appellant submission, and the RP didn't report certain transactions which are fraudulent in nature, nor allowed the applicant to make the representation before the COC. That the application filed is not maintainable because application under section 66 may only be filed by the RP or the liquidator. That was the respondent submission, and the RP was satisfied that there was no reason to file an application under 66 of the code, and the COC agreed to the same.
COC also agreed to this. Now let us see the held portion.
So sections application under 66 is to be filed only by RP or the liquidator. So herein the applicant, not the resolution professional, but only a dissenting financial creditor, and in his capacity has no right to file the present application. But the transactions which are mentioned in the application under section 47 and 66 does not qualify the criteria of undervalued or fraudulent transactions.
So this is a unique case, Ankit, where a dissenting financial creditor filed an application basically objecting the resolution plan, and he also took this argument. He also took.
So I think we don't know the nature of transactions that were actually being talked about by the dissenting financial creditor, but it appears that maybe the transactions were not in the nature of undervalued or fraudulent transaction, and therefore everyone or the COC or the RP were of the opinion that this is not required to be followed up. Another option for any creditor would be to go to IBBI and say that the RP is not completing his duties. That is also an option that would be available to a financial creditor if he can't file the application under 66 before the NCLT. He can certainly go to IBBI and say that this should be filed. Amit, Dinesh Chandra.
We have now finished the judgments of NCLAT, and we can now move on to
the previous one was also NCLT only.
Oh, yeah. Previous one was also NCLT.
So Amit Dinesh Chandra Patel versus Chandra Prakash Jain, that is Syntex Prefab and Infra was the matter here, March 22 judgment.
Yeah.
So whether the audit of 6 years is beyond the purview of IBC as per section 43 and 50 dealing with preferential and extortionate transactions respectively, which provide for a look back period of 2 years preceding the insolvency commencement date. Let's see what
it was also similar to the earlier judgment where the objection from the appellant means the suspended board was that how can the RP go beyond 2 years look back period. In this case also, the COC decided to undertake the audit of transactions from 2015-2021, that's 6 years, and RP informed the auditor that the audit for the period 2015 and 2018 will not be form part of the transaction audit, but will be considered as forensic audit. Aggrieved by the audit to be conducted from 2015, the suspended management filed an application stating that the 6 years audit was violative of section 43 and 50. So it was a unique case, Ankit, when the COC decided that let's go ahead for 6 years audit. RP somehow said that I will consider only for 3 years. For rest of the 3 years, balance 3 years, it should be considered as forensic audit. And since there was a confusion between the RP and the COC, so the suspended director, they attempted to take benefit and they filed an application that they are going ahead with 6 years. And even so this is what is the section 43 submissions made by applicant, the section 43 and section 50, which deals with the preferential and extortionate transactions respectively specify the look back period of 2 years. Therefore, audit of 6 years is beyond the purview of IBC. Now, the respondents said, they also gave a kind of factual argument that in this case, there was a demerger from a parent company in 2015. And upon verification of assets, it was discovered that very few assets were physically found, though the properties, plant and machinery were shown at higher value. So this hints the presence of fraudulent transactions under section 66. And therefore, because section 66 does not provide for provisions for look back period. So this was again correct, Ankit, because see, unless you go into the detail, you would not know whether this transaction is under section 43 or 45 or 66. And the investigation has to be done. And only after that, when a transaction is seen as covered under section 43, it can only be for 2 years. And in case a transaction is under section 45 only for 2 years, then again there is a concept of a related party or unrelated party. And in case of 66, already the appellate authority has held multiple times that there is no look back period for the for section 66. So therefore, I think these are the various things that the suspended directors, they try to save themselves from avoidance transactions. So this is what I feel, that a lot of litigation is on account of that.
So in our opinion, in based on my experience with forensic audits, I feel that extortionate transactions are very, very rare. Then comes the turn of, in terms of rarity, the next comes is undervalued. Next comes is preferential transactions. They are also rare. But then undervalued asset sales are a good area of finding something that has happened in the company. And then, of course, when you talk about diversion of funds, that again falls into the category of 66. So therefore, the whole activity of finding if there is any diversion or misuse or misapplication of funds which were borrowed, that then gives a lot of information on 66 applications.
Right, you are, Ankit. So we can go ahead with another judgment, which is Ashok Velamur Shadri, the liquidator of Archana Motors Private Limited versus Shibu Job Chiran, who is a suspended MD, NCLT Kochi judgment, and again very recent. It is the November 22 judgment from NCLT Kochi. Whether the provisions of the Companies Act can be invoked for matters of execution of an order passed under the Insolvency and Bankruptcy Code. Under Ankit, in this case, in fact, there was an order, there was a payment, 21.37 crore, which was actually which was due from the management because of the fraudulent transactions. NCLT also passed an order that there was a management took part into this kind of fraudulent transactions. Now, 21.37 crore was recoverable. So in this case, the applicant means the RP, filed an application for execution of Section 66 order. Execution of Section 66 order, because the Section 66 order can only be order where some recovery is ordered. That this much of recovery it can be made from the directors. Now, what the applicant did, he filed an application under Section 424 of the Companies Act with read with Rule 56 of NCLT rules for the recovery of the fraudulent transactions money. So then the applicant said that the applicant is constrained to invoke Companies Act and Rule 56 since Honorable Tribunal directed the applicant to do so under the said order, finding transactions to be the applicant. And the respondent said that the adjudicating authority never gave any directions like this, that you invoke Section 424 and talk about it and recover the money. And it was held by the NCLT that the provisions of Companies Act 2020 cannot be invoked in the proceedings under Section 1 IBC for recovery of the money. So that's a kind of execution of the order.
So what do we do then for executing the order? You go back to NCLT and say that this money is not being given by this person and he's not cooperating. That's it?
No,
or do you?
I think the execution of any order for recovery, that has a separate jurisdiction. It goes to
it will go to commercial court, or it will
goes
maybe
to High Court. It goes to High Court.
It will go to High Court.
And then there are processes where the High Court will find out the assets of the person, and then the assets can be attached. Then High Court has a department of
But if Section 66, if the order is against a CD, can't there be a simple demand notice and a subsequent IBC filing under Section?
See, like the promoters are normally the individuals. So in case
if it is a corporate, I'm sure if they may, I'm not talking about those cases where they're not corporates, but where they're corporates, an insolvency application can also be filed.
I think since any decree, if it is a debt, financial debt, or it has to be a operational debt, only then Section 9 or Section 7 application can be filed. Recovery of any order, the recovery of any kind of damages or any kind of fine or any kind of this kind of money under Section 66 cannot be considered as a debt under Section 7 or 9. So therefore, the normal recovery route would be applicable.
The submission from Ankit Garg saying that under order 21 of CPC, a civil court can also order execution of the order passed by the
That's what
AA.
I said.
Yeah,
That's what I said. Civil
yes,
court or
yes.
high court.
Civil court or high court. Perfectly good. So let's
Next,
proceed. I think there are a
okay.
few laws. So this one is Worldwide Online Services Private Limited, January 21 NCLT judgment. Let's move forward. So here the question was whether the respondent who has neither the promoter, suspended director, nor part of the management of the CD can be held liable under section 66 of the code. So in the instant application, the basically the avoidance RP had filed it, and one of the respondents was neither the promoter, suspended director, nor the part of the management.
So yes, I think you can.
It was held that that any person under section 66(1) suggests that outsiders can also be can be held liable for fraudulent trading as long as they had a dishonest intention. Therefore, the respondent who is neither the promoter, suspended director, nor part of management of the CD can be held liable under section 66 of the code.
So we can cover anyone in case we feel that somebody else is also involved into this fraudulent trading. So we can involve even those people also. This order is very good. And in fact, we at AAA, we thought right from the beginning like this only. And there is no ambiguity on this in our mind. But of course, this is now confirmed by an NCLT order also. So RTIL Limited versus Nitin Kastliwal, NCLT Mumbai, November 21 order. Whether bad commercial decision can be considered as fraudulent transactions under the provisions of section 66 of the IPC. So in this case, in fact, the promoters argued that whatever transactions have been reported by the RP or the liquidator, these are not the fraudulent transactions. These are the bad commercial decisions. So they, in fact, somehow convinced the bench that the transactions were reported by the auditor, and it was only highlighting the transactions which are potentially fraudulent, but that does not have any reference to the siphoning off or diversion of funds. So maybe a case where some money has been given to a customer and the customer has not paid back the dues, or the money, the item sold and the are not recoverable. So these can be bad decisions and bad commercial decisions that they couldn't understand the creditworthiness of the customer, and finally the money was not recoverable. So on these kind of transactions, it was held by the adjudicating authority that cannot be considered as fraudulent transactions. So now I think this is clear, but I somehow feel that this will open up a kind of exit route for the promoters. Everyone will try to
giving this color that this was a bad decision is very easy. So,
yeah.
But at the same time, it can have a very thin hairline difference.
Yes. Intent to defraud or any fraudulent purposes. So it all depends upon the facts. Because in case I sell my goods to a person who has no credit worthiness, and then I say that now the money is not recoverable, it can be a bad commercial decision as well as, and it can also be with the fraudulent intent when I knew fully that this particular company that I'm using for
the criminal law, they use the term mens rea, that there has to be an intent so that's the idea that they've talked about. So let's quickly have a look at these two judgments because it's already 12 o'clock.
These two judgments, in fact, we have attended in the earlier webinar also. So whether under this is the first judgment is regarding the Venus Recruiter Delhi High Court judgment. It was in November 2020. It is being used much, and it has been relied also in a couple of cases. Whether under the IBC an application filed under section 43 for the avoidance of preferential transaction can survive beyond the conclusion of the resolution process, and the role of the RP in filing pursuing such applications. So this is a case where the COC approved a resolution plan in March, and in April RP filed an avoidance application. That means the April means after the resolution plan is approved by the committee of creditors, and after about 10 weeks time in May, on May 15, even the resolution plan was also approved by the NCLT. And then the avoidance transaction, there was an interim order passed on the avoidance transaction, and then the suspended board of directors or the accused, he went to the Delhi High Court that now the when the order is passed, interim order is passed by the adjudicating authority on avoidance transaction application, while the COC has already approved the resolution plan. So what is the capacity now? Under what capacity the application would be pursued? RP is not RP. The resolution is completed. RP has already exited his office. He cannot wear the hat of the former RP. That's not provided in the law. So therefore, these applications now cannot be pursued by the former RP hat. So I think thereafter it was provided that in a resolution plan can be approved in case it is provided in the resolution plan that how the applications would be dealt with and how the proceeds would be distributed in case any such proceed comes from these avoidance transactions. So this is all the recruiter, the Venus recruiter judgment was. So this is again like in the case of Neeraj Agarwal RP versus Amrish Fresh Private Limited, the same judgment was also used very recently. Anuj Jain, Infratech versus Axis Bank, it's a Supreme Court judgment in February 20, where the section 43 judgment was in fact 43. It was very clearly defined by Honorable Supreme Court that there are five parameters that has to be seen for transactions under section 43 of the code. One is whether such transfer is for the benefit of a creditor or a surety or a grantor. The answer has to be yes. Whether such transfer is on account of an antecedent financial debt or operational debt or other liabilities owed by the corporate debtor. So that means that as on the date of the preferential transaction, there has to be a debt, old debt, antecedent debt means old debt. And the answer has to be yes. Whether such transfer has the effect of putting such creditor or surety or grantor in a beneficial position as compared to the other while using section 53, the answer has to be yes. If such transaction had been for the benefit of the related party, as to whether the same was made during the period of 2 years preceding the insolvency commencement date, and if such transfer had been for the benefit of unrelated party, that the look back period also has to be assured, and whether this transaction was a normal business or not. But that is the excluded transactions. If the answers are the last one, the answer has to be no for the last one. That the transaction was not an excluded transaction, then it was considered to be a kind of section 43 preferential transaction.
So few quick questions. Section 92 application can be filed by liquidator, right?
Section 92 file application cannot be filed by the liquidator. The liquidator will file an application under section 35.
Oh,
so section 92.
So he will file an application under section 35, but he can obviously file an application under section 66. There is no gap. Yes. So then another question is that since transaction auditor appointment needs approval by COC as regarding costs, COC would demand the details of the report and its findings before the application is submitted. Will not such a demand tend to compromise on the confidentiality of such report? I don't think there is a problem because the COC can be told that, okay, this is the amount that is recoverable.
Let us understand why confidentiality is required from COC. Let us try to find out. One, that the COC will only contribute about the facts of the case. Two, the COC will also understand if there is a possibility of recovery in such cases. Three,
commercial decision with respect to resolution plan passing will depend on what might be the chances of recovering anything from these transactions also.
No, like Dansi, the question is at times the COC may say that we are not interested to filing an application before the adjudicating authority, even if it is reported by the auditor. That decision cannot be accepted by the RP because it is the duty of the RP and not the duty of the COC. The COC's only duty is to approve the reasonable fee for litigation, reasonable fee for the auditor. but the COC cannot say no to filing of the application.
So the look back period can't go beyond the 2 years for other than the 66 section 66. That's very clear.
Other than 66, it can go to any extent.
Yeah, 66 can go to 66 can go to any extent, but other 3 cannot go beyond 2 years or 1 year, depending on related party, non-related party.
Yeah, yeah.
So 18(1)(f)(6), I'm not sure which section or what the section refers to. That is a question that is coming in. So I think the few more questions.
I can actually see 18(1)(18). I think it is the duties of the RP, na? 18 duties of the interim resolution professional. 18(1) तो नहीं हो सकता. 18A is there, na?
Section 18(1). This is not regulation. Section 18(1)(f)(6).
Take control and custody of any asset over which the corporate debtor has ownership rights as recorded in the balance sheet of the corporate debtor, or with information utility, or with the depository of securities, or any other registry that records the ownership. So this is what is the section. What is referred to? What exactly is the section? 18F.
18(1)(f)(a).
FA.
F 18(1)(f)(6), clause 6.
So 6 is the asset subject to determination of ownership by a court or authority. Records of the ownership, including. So all these assets, the RP has to take the custody of all these assets, even those assets also where the determination of the ownership is pending before any court. RP has to take the control and custody.
So I think yes, I think all answered. Can a claim submitted after verification be withdrawn by him? No, there is no possibility of withdrawing the claim under the CRP process. However, the claim can be withdrawn in 15 days in the liquidation. There's a possibility. Okay.
I think during liquidation there is a possibility.
There is no possibility, as you guided the other day.
Yeah, yeah.
So
in IBC, there is no. Still, I can even see the one moment. No, there is nothing which can be withdrawn. Whereas in the liquidation process, there is a possibility of withdrawal.
So I think thank you everyone, and wonderful session today, I guess, where we would learn so much about PUFE transactions. So brings in some confidence on, yes, possibility of a PUFE transaction serving some justice to lost assets of the company. Thank you so much everyone for joining in, and we'll continue next week. Next week we need to think of how we will do it, but then we can actually
we'll see, like, who in case we would be traveling overseas, then somebody else will do from AAA.
Yeah.
Yes. Thank you, participants. Thank you. Thanks a lot.
All right. Thank you, everyone.
Thank you.